internet that are available. Now, for us, for our examination purpose or our competition purpose, it is sufficient that we know only what are the changes. We need not, by and large also, if you see, there are not very many differences except for the fact, am I audible?
Yes, madam.
Except for the clubbing of some sections or removing some sections, modifying some sections, eliminating some words and all. By and large, the differences are not very many, and because of shuffling of sections and all, there is some difficulty in remembering, because old version we are familiar with some sections like 32, 27, in the Evidence Act, and your 154, 174, like that we are familiar with the old sections. So for us to master the new sections, it may take some time, but then the concept and the content of the sections will remain the same. What I mean to say is, nomenclature has not changed and the content part of it also has not changed, except for shuffling of some sections, removal of some words, and electronic evidences are given more preferences. And earlier we used to see IPC and all, we used to remember that any crime, when you want to categorize, when you want to grade crimes, our concept of grading crimes was based on whether the crime is against the state or against the nation. So that we thought is the grave crime that somebody can commit, isn't it? Now, because nation is a representative of people, so a group of people, lakhs of people, crores of people will be there. So when nation is not protected, individuals definitely will not be protected. So nation's protection will be the foremost thing. So that is how the IPC is trying to grade the cases in older version. Now in the newer version, if you see, the topmost priority is given to womanhood and children. So any crimes against these people, they are given top priority, and these sections you will see coming in the forefront. Later on, all sedition and then crimes against nation and all, they are coming at a later part of the act. So that is the importance that is given. So these, except these things, I don't see much of the difference in the change. And another important thing as far as the major reason is that all general explanations, we used to have a chapter called we used to have a chapter called general explanations. Now this chapter 2 from 6 to 52A in the IPC, these have been covered in the general explanation. That is one major reason for this. As you can see, if you have somebody has got the Bear Act, because I have already left a message in the WhatsApp group that you should also have your old version of IPC, so that things become easy for us to understand and all. Now if you look into the older version, IPC version, then you see chapter 1 is of course introduction, that is title, extent, and then definite extension and jurisdiction. These are the things normally which are there in the introduction part. And then when it comes to Indian Penal Code, there is a chapter 2 where general explanations. Otherwise, normally in any other act, they are called definitions. So why only in IPC it has been a different word is used for definitions called general explanations. Now these general explanations which are listed under chapter 2, they are ranging from section 6 to 52A. Now this is a little major change, and now you see that total number of sections in the older version of IPC used to be 511, if you remember. 511 was the last section. Now there is a tremendous reduction in the number of sections. If you see the Naya Kanun, then which is called the what is the new act called in place of IPC? Can anybody tell me what is the name of the new version of Indian Penal Code. Bharatiya Nyaya Sanhita. That is the full form of that. Bharatiya Nyaya Sanhita. Then in that, if you see old version of IPC, how many sections were there? If you have a Bare Act, please see and tell me.
511 section.
Now, what is the reduction? Can anybody tell me how many sections have been? What is the current?
Now presently it is having a 358.
This is 358 is the one now which is being reduced. So you can see, I mean, why the reduction or why some modifications. If you see, you will understand that subsections. One thing is all the definitions that are contained in the subsection 2. When instead of a complete chapter for general explanation or the definition class from 6 to 52A, they said they are all incorporated as section 2 and then subsection. Normally, for us to remember, we were given a thumb rule that in every act chapter 2 or section 2 will be the definition clause, and the subsections 2A, 2B, 2C, like that will be definitions for different words that have been used throughout the act. That's what we were given to understand. So similarly here also, so they have done like this under section 2 as subclauses. These were given, and sedation, as I told this is given top priority in earlier version. Now in this new Sanhita, this Nyaya Sanhita, they have given topmost priority for women and children. Another thing is the first time terrorism as an offence is recognized under IPC, and then it has got a clear definition, and the new act, the section that deals with it is 111. So they have given a complete emphasis, force on terrorism, and a definition completely is clearly defined under chapter under section 111. That also you need to. And hither too in IPC we used to have only burglary by night, by day, isn't it? Robbery, and then dacoity, extortion, these kind of things were there. But then snatching for the first time is introduced. Now it is been defined under 302 of BNS, Naya BNS में. So they have included one addition of property offence called the snatching, and taking away movable property, that is taking away movable property from the possession of any other person. Only difference that we can understand between theft and snatching is the extent of the offences. Now theft in itself is a more inclusive category of offence, and of which snatching we can say is a narrower subcategory. One is a genus and the other one we can call it as a species of that. Then again the new punishment, that is reformation. Because the criminal justice system are prison reformations, they strongly believe in reforming the person rather than giving punishment. They feel that reformation is the right way of reforming somebody. So they have included as a new punishment community service, isn't it? Community service is a very good concept. Now you are punished, and then the new punishment is not put you behind bars and then make you a useless person at the end of the day, but then you are given a new dimension of punishment in that, the reformatory punishment, in that you go and then serve the community. That's what is given under punishment as against the crime called defamation. Now another thing is you have seen that suicide. I mean, if a person survives, then of course you have punishment, and if the person is successful in committing that offence, that means after suicide there is nobody to punish, the person is dead and gone. So provision 224 in the new Kanun, that is BNS, there is a definition given: whosoever attempts to commit suicide with the intent to compel or restrain any public servant from discharging his official duty shall be punished with simple imprisonment for a term which may extend to 1 year or with fine or with both or with community service. Here also if you see the person who is survived, definitely he has to undergo some punishment. Here also they have included the new dimension of the punishment called the community service. So that is the only difference in the as far as the suicide is concerned. Now public servant, especially the importance that you have to observe is that if somebody is disrupting, that is while carrying out, suppose a public servant is carrying or doing some official work. Now if you are disrupting that work, then definitely that will be treated as an offence, and then for that 1 year punishment and then fine and all, plus you have the community service also is one of the things that have been given. Now this other changes, as you can see, provisions, one more thing is keeping the transgender thing, third gender in mind. So they have made some of the sections, especially sexual assaults, they have removed the gender specificity. That means they have made it gender neutral. So that means even the other gender is also equally prone to that kind of offences. So that keeping the members of the LGBTQ community, they have also made some of the sections as gender neutral. That means it applies equally good both for men and women, and of course the transgender, as they are called LGBTQ. So that is another kind of so as I said, women and children are given more priority, or rather protection of women and children has been given a greater precedence over the protection of general human body. And offences relating to the human body are arranged so as to offences involving killing are placed first, and then followed by other offences of the human body in the ascending degree of that. This particular phenomenon you also observe in normal IPC section also. Now, other important addition what we can think of is concerning organized crimes, which was completely missing in IPC. Now they have added this in the new act. So organized crime is been given. So this primarily they have borrowed it from special statutes like Maharashtra Control of Organized Mokoka, they say. So that is 1999 Act. They have borrowed this concept of organized crime, and they have incorporated that in the Naya Kanun now. So this is what is the socio political aspects. They were also taken into account when framing the sections and all. They have included the socio-political aspects also into consideration. That is one thing. Now, by and large, this is the comparative thing of the IPC. I mean, by and large, I don't say this gives a complete analysis section by section. I don't say, but then by and large, this is what is under the IPC. Now, as I said, if you just broadly, if you see, now as I said, section 33, the different things are given, single includes plural also, like section 20, Court of Justice. So like that, there are different sections that are given. So in the new thing, they have included them as section 2 main section and subclasses. For example, in BNS class 2.1 Act is defined. Likewise, court is defined under 2.4 and gender is similarly defined under 2.9. So what you can observe in this is, instead of a separate chapter under general explanations where sections from 6 to 70, 50 to A, they are given as separate sections. Now the major thing, the reduction in number of sections, if you see, analyze, and that is only because of all of them are put under one umbrella called clause 2, and under clause 2 there are subclasses again 2 within bracket 1, 4, 9, like that. They have put all the definitions under the clause 2 with subsections. Mental illness, for example, judge. These are given as separate sections. For example, the judge definition is given under old version of section 19, now becomes the new version of section 2 with subclass 15. So like that, most of the definitions get reduced to section 2. So with that, 6 to 52, if you can count those many sections, get reduced simultaneously. That is the reason why you are now ended up with 358 at how many sections we said? Reduced to how many sections? 511 got reduced to
358.
358 is the thing. So major thing that you have to remember is this section, chapter 2 wala. Then you have again the other definitions like 84. What does it talk about? 84 in the old version, it talks about insanity, if I am right, unsoundness of mind. 84 in the old version of IPC is talking about the the mental illness or unsoundness of mind. Now what is the major thing? The mental illness in section 2 of the mental health care, they have taken that into as a broad restrictive. It includes mental retardation, which is defined as a condition of arrested or incomplete development of a mind. So this is the major thing that you need to remember. But this also they have borrowed from the act called Mental Health Care Act 2017. So they have taken this and they have made the definition a little broader. Now it says mental retardation or mental incomplete arrested development of the mind is taken as the thing. Now however the test under the new provision remains unchanged, but the standards used for its invocation would still apply. Therefore the stereotypes associated with 84 or IPC would continue. That means except for these broader definition, the definition you don't find much change. That's what it says. Now other major things if you talk about, now what does 89 say? 89 of older version of IPC, if you observe, it is talking about the good faith. So anything which is done while taking due caution and then understanding the consequences is nothing but called as good faith, isn't it? So somebody does it with with the due care and caution, and not doing it without not harming the other person is is basically called a good faith. Now the mental illness again, it is incorporated here. The Mental Health Act is also taken into consideration here while talking about the because there are clauses again, firstly, secondly, thirdly. If you see IPC, it is been given under that. Now coming to other major differences, now if you see 103, these things come under right to private defenses, isn't it? Right to private defenses is a very important concept or aspect what you will find in general exceptions, isn't it? There is a old version of IPC, you see a chapter 4 under which general exceptions, that means these are all special privileges for an accused. So the first thing the defense person tries to do while supporting his client is that try to bring in the case of an accused under the general exceptions, any one of the general exceptions, and then if he tries to fall back on these general exceptions, especially the defense lawyer, then the onus or the burden shifts. Now normally the burden or onus is on the prosecution, normally we say that, but then when the accused or on behalf of the accused, if the defense lawyer wants to put the case of his client under this category of general exceptions, now we say that the burden shift. That means it is for the accused or the agent representing the accused. It is their duty completely to bring in some kind of an evidence to show that his case comes under the general exceptions. So under general exceptions also, we say that right of private defense is very, very important. Now that is mentioned as 103, the right of private defense of property now is mentioned under 103, isn't it? Now that is there in clause 41, the right of private defense of property extends under this. So the major thing is the change from housebreaking by night to housebreaking after sunset and before sunrise appears unnecessary. I don't know whether they have included that, but then one of the comments of the renowned lawyers and all is, I mean, it is not necessary. Why they have unnecessarily included this and all is their comment. And you can also see that mischief by fire has been expanded to additionally include mischief caused by explosives. Earlier, you don't find, if you see the definition and all, you don't see the mentioning of explosives, because even explosives also cause a tremendous fire and all. So since the old version of right to private defense under section 103 doesn't include explosives, so it only says mischief by fire. But the new version, the BNS, contains another important addition, that is, by using explosives also, if that is going to generate fire, and definitely any explosive, low or otherwise, will also have the fire component involved in it. So they also included this word under mischief. So they said mischief caused by explosive substance should also have a place in that, is what is given in the thing. Then you also see that there is a clause 48 in the BNS now, which says that there is an expansion. I mean, the definition of abetment also will be given an expansion. A broader definition of that is given, which is, you don't find any equivalent in the older version of IPC, is another major change that you can find. So like that, in sexual offences also, as I said, of course there is no equivalent as such we can compare with IPC, but then in the new act, that is BNS, clause 69, if you see, is, I mean, new offence of deceitful sexual intercourse. That's what they have mentioned, and not amounting to rape. Like murder not amounting to culpable homicide not amounting to murder, culpable homicide amounting to murder. Like that we have clauses. In this also they try to bring in a new concept of offence of deceitful sexual intercourse. Now the terminology that is used here is not amounting to rape. Not amounting to rape is given. The term used earlier in older version is 376 of the IPC. I mean, they said 376C IPC, that is being covered, but the new version they have used 68 and 69 as the sections. Then now you also see a major age phenomena. I mean, especially 376 DA in the old version. Now if you see where a woman under 16 years of age is raped by one or more persons constituting group of or acting in furtherance of a common intention, each of these persons shall be, so you see that definition under 376 D capital A. Now in the new version it becomes section 70, clause 70, subsection 2. Now the change that you can observe is, here we said 16 years. Now the enhancement of age you can see here, 16 to 18 years, it expands the scope of the provision, and those offenders who commit gang rape on women between 16 to 18 years age, and additionally this offence is now punishable with death penalty. So this is also is another change that you can observe. So what is the new another change in sexual offences? Under 376 capital DA in the old version of IPC, now you see the age thing. Age thing is increased from 16 to 18, and punishable with death is also included in that. Then The rehabilitation of the victim is also taken into consideration, provided further that any fine imposed under this section shall be paid to the victim. So that's what it is given. Now, and here also 354B, if you see the old version of the and sexual offences kind of a thing, assault and all, I mean, not a sexual offence, any man who assaults or uses criminal force to any woman or abets such act with intention of disrobing. This is outraging the modesty kind of a thing. So disrobing or compelling her to be naked and all. Now you see here they have said any man. If you see the definition, it says any man. It starts with the word any man. 354B, capital B. If you see, it starts with the word man. Now under clause 75 of equivalent section, if you see, now whoever, instead of man, it starts with the adjective whoever. That means the offence is now made gender neutral. Gender neutral. This is also one thing you have to observe. So most of the sexual offences, as I have initially said, they are made gender neutral because we have introduced the new concept of LGBT, the third gender, and also to make things a little broader, they said the things, the definitions of gender should be, it should be neutral, gender neutral, instead of gender specific, they said it should be gender neutral. So this is one major thing, also one change we have to observe. Now, if you see the old version, another very important aspect in sexual offences, if you see, now 377 in earlier IPC version, we said unnatural offences. Doing carnal intercourse, doing an intercourse against the nature and all, bestiality, sodomy, incest, these kind of things were included under 377 under the category of unnatural offences. Now, under BNS, they have removed this. They said that there is no equivalent now for such kind of offences, and it completely repeats this section. BNS repeats this section 377. So this is also one more major thing that we have to observe. 377 equivalent is not there in new BNS, and it is been repealed in the BNS. Earlier version of that was, unnatural offences under the category, under the section 377. Now, another thing is, 509, if you see 509, whoever intending to insult the modesty of a woman utters any words, makes any sound, this is outraging the modesty, 509 in IPC. Now the wording is little changed. So the words that have, the phrase or the words that have been used in the section, new section is in any form, they have used the word in any form. So that means they are trying to expand the scope of this object of the section. That's what we need to understand. Now, similarly, now the old IPC, if you see the 498, what is 498? Whoever takes or entices away any woman who is or whom he knows or has reason to believe to be the wife of any other person and all, this is what we have said in the old version. So if you see, go back to the section in the Bail Act and then try to see what is that the 498 all about. I think, is it not adultery, if I am right? 498, 497 is adultery, not 498. Adultery is 497. Now 498 is enticing or taking away or detaining with the criminal intent of a married woman. So the difference that you have to observe is from that man or from any person having the care of her on behalf. So these are the words that have been included. Now, So there is another new provision, if you see, new provision which is given as clause 93, but then there is no equivalent. If you see in IPC old version, there is no equivalent for that. But then it says that whoever hires, employs or engages any person below the age of 18 years to commit any offence shall be punished with imprisonment of either description or fine provided for that offence, as if the offence has been committed by such person himself. So this is what is given under that. So the new provision which criminalizes hiring, employing, engaging minor to commit an offence. However, hiring, employing, engaging, there is no clarity in that. That's what the advocate says. But then there is no equivalent, because the minors, when they are hired for employment or any other work, then that act is also criminalized. There is a new provision that has been created in the new canon. And another major thing that you can observe is 101(2) clause is given, and you don't find any equivalent section under IPC. But this is a little important. Why is it important? Now it is, we can presume that it is an aggravated form of murder. Now aggravated form, whenever we say dacoity, robbery, and then the theft and extortion kind of a thing, one is an aggravated form of the other. Robbery, dacoity, if you see, dacoity is an aggravated form of robbery, because more people are involved, I mean 5 and above, so that number is very specific. So when we say that when more people are involved, it will be construed as a more grave crime. So similarly for murder also, they are trying to grade that aggravated form of murder, when a group of 5 or more persons acting in concert and with a specific intention in mind. It provides for a minimum punishment of 7 years and maximum punishment, if you see, is death. Similarly in dacoity also, if you see, similar kind of provision is there. Even preparation, attempt, everything in dacoity, if you see, is punishable, unlike other offences where preparation is not an offence prima facie, unless it culminates in action and all. Prima facie it's not an offence, but exceptions are there, like dacoity and all, where preparation also, mere assembly preparation itself is an offence. So like that, here also 101 clause 2, if you see, of course no equivalent in the sections for IPC, but it says a murder can be construed as an aggravated form when it is committed by group of 5. And if you see the minimum and maximum punishments, minimum that can be given, because the judge cannot give anything less than that. I mean 7 years is the minimum that he can give, and maximum can go up to death. That means capital punishment can also be given to such kind of offence. That's what is given. Now one more thing that you have to remember, that when it comes to 303, what is 303 in the old version? It says whoever being under sentence of imprisonment for life commits murder shall be punished with death. So this is the convict, convict who is already undergoing some sentence and all, life imprisonment. So if he commits crime, then again it will be, the life imprisonment will be converted into death. That is what is under 303. Now if you see, this 303 was struck down by the Supreme Court in the case of Mithu versus State of Punjab, and it has been reintroduced again as a clause 102 with a modification that allows for a mandate of minimum sentence of life imprisonment with no possibility of remission. That is the change that you can observe. Now this is also very interesting. Now if you see clause 104 subclause 2, Now they have introduced this offence, somebody, committing a homicide, but rash and negligent act, then if that person flees away from the scene, then they have criminalized such acts. So that means criminalizes failure to report the crime after committing it. It is an aggravated form of the offence punishable under section 1041, since it provides a maximum punishment of 10 years. This appears to cover cases of hit and run. Now, earlier, hit and run, most of the time it gets its name only by that, somebody, a speedy vehicle comes and then it hits the pedestrian and then it flees away from the scene. So, there is no kind of a liability and unless you be after him and then catch hold of them and then prove the offence. Otherwise, he can he can hit the pedestrian, he can injure the pedestrian, and without bothering what has happened to the pedestrian, whether he was grievously hurt or whether he was bleeding heavily or what is the fate of that person, without even bothering about him. If the driver flees away from the scene, then we call such type of cases as hit and run. Now, in this new BNS, what you see is they have criminalized, they have criminalized this particular act. If somebody is failing on their duty, maybe it is an accident, or maybe with overconfidence you are going with a high speed, you tried your level best to apply brakes, and then to your misfortune the brakes were not functioning, and then somehow the mishap has happened, and in the process you hit a pedestrian and he got badly injured. And it is your primary duty at least to ensure that you report this matter to the police, and then ensure that you join him in some hospital nearby. At least if there is some first aid that is given, the person, at least there are fair chances for him to survive and all. So to make to a step towards this particular act, they said, whenever there is a rash and negligent driving kind of a thing resulting in a homicide, now the offender is liable for punishment, and he tries to criminalize the failure to report to the crime after committing it. Now we can say it is an aggravated form, and now the hit and run cases, it is valuable now. It covers all rash and negligent homicides where the offender or the perpetrator is trying to escape from the scene and does not report the crime to the police or the magistrate. So this has been criminalized. That is one good welcome sign in the BNS Act. Now, another thing, if you see 305, section 305 under the old penal code, if any person under 18 years of age, any insane person, any delirious person, any idiot, or any person in a state of intoxication commits suicide, whoever abets the commission of such a suicide shall be punished with death or imprisonment for life, or imprisonment for a term not exceeding 10 years, and shall also be liable to fine. That is the old version. Now what does the new version say? That is equivalent of 305 in BNS is 105. It says, if any person under 18 years of age, any person with mental illness, any delirious person, or any person in a state of intoxication commits suicide, whosoever abets. So only thing is, what you see is replacing the words any insane person and any idiot with any person with mental illness. So they are, that means they are trying to broaden or expand the scope of the section. So in order to cover large number of people within the aggravated offence of this kind. So this is also another thing where the definition is the same, but then there is a little expansion to cover many more people under the category of insane person. Instead of naming them as an idiot and then insane person, a general term, a very broader term called mental illness. Mental illness covers so many other mentally related ailments and all. So they have used this particular wording there. And then another thing what you can observe is the older version of IPC, you see there is a section called 310, which reads as, whosoever at any time after passing of this act shall have been habitually associated with any other or others for the purpose of committing robbery or child stealing by means or by accompanied with a murder is a thug. Now, you see that there is no equivalent in section BNS. Now, the advocate feels that it is a very positive change. Now, this provision previously criminalized people based on their caste and status, such as nomads. So there are some tribal people, because just by virtue of their birth being as that particular tribe, under the name of Thug and all, they used to be cases which have been booked against them, and then they used to be unnecessarily been harassed and also. Just to remove that, they said, they have removed that, and you don't find any equivalent in BNS now. So the advocate feels that it is a very good sign, because now you are not criminalizing people based on caste, creed and status, That's what our constitution also says. Nobody, before law and before constitution, everybody is equal and everybody should be treated socially, economically, otherwise also as equals. That particular concept you can clearly see in this particular section. Now, similar is the case with 311, 310 and all similar clauses you can see. Now, another new thing, as we have already discussed in general discussion, is organized crime. For the first time they try to introduce the definition for this, and you don't find any equivalent in IPC section. Now the new BNS, it has got a clause 109, clause 1. Now it says, the new definition says, any continuing unlawful activity including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offences. You see the gamut of offences that have been included. Very wide gamut of offences have been included here, so including the cyber crimes having severe consequences. But only thing is, when you use words like this, cyber crimes having severe consequences, what are those categories of cyber crimes which have serious consequences? Unless until the law is very clear, verbatim, if it is not very clear, then it will be problem while awarding punishments and all. So except for that wording, otherwise it has encompassed and gave a definition, including in its definition lot many activities. So it is very wide definition. Human trafficking is included in that, prostitution is included in that, and then ransom by the effort of groups is included, and then crime syndicates are included in that, and use of violence, threat, intimidation, coercion, corruption. You see, such a broad definition is been given, and then this is a very new welcome kind of a change that has been brought in BNS. Now organized crime, for the first time you see the definition under this, and IPC we don't find any equivalent section which can define organized crime. Then again, if you see, there is one more addition, like in the form of 109 section subclass 4. It reads as, any person who is a member of an organized crime syndicate shall be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life, and shall also be liable to fine which shall not be less than 5 lakhs. Now this section is taken from Mokoka. The punishment is also same as is seen in the jurisprudence from Mokoka. They will apply. But the thing, equivalent section, if you see in IPC, you don't find that. That means it's not available. Equivalent is not available in IPC. So some sections have been brought from Mokoka only, where you see UAPA provisions and then Mokoka, they were borrowed, especially organized crimes and all, they were borrowed from these acts. There are special acts, so these words have been borrowed from those sections, from those acts. So it talks about the proceeds of organized crime and all. And there are these 109 and all, they're all for, there are different clauses, 5 to 6, 9, there are different clauses and that. And then it only says what should we do with the proceeds of the organized crime, and then what kind of punishment that can be levied and all. If it is cash, if it is some funds and all, if there is a traceability, if you can prove that the property has been acquired by the proceeds, illegal proceeds of the crime, if you can prove that, then there can be punishment that can be levied. Then so these are some of the what you can call major changes that have taken place. I mean, except for the addition of a few sections and a few concepts, by and large, only thing, I mean, what is the logic I don't understand, but you can also tell me what could be the logic, why the serious crimes. Earlier we used to say that serious crimes are those crimes, or grave crimes are those crimes which are crimes against the state. Or next comes offences against the community. Then the next comes the family. Then comes the individual. That is how we have understood. Now suddenly in the new act, they have given priority to women and children, but without any nation, because nation and state is if you see the hierarchy of the society, it will be on the top. So if there is no protection for state or the nation, where is the protection for the individual? I don't understand the logic. Can you, can any one of you react? Why this kind of a change? What could be the logic behind that? But this is one area which I am not able to understand yet. Why that is been? I am not convinced the way it is been given. But then you may have a different opinion on that. I would like to hear from you. Yes, anybody?
Good evening.
नहीं समझ में आ रहा जो हम पूछ रहे हैं.
Yes, sir. Yes, ma'am. Because most of the crime what we see today is against the women and children only. Majority of the crime.
That's fine, but then if the nation is not, because nation is at a higher pedestal, isn't it? Nation and state, they occupy a very different state, you know. So when the
it is that 124 section they have remodified. Actually, same content exists in some section now. That offence is still existing against the 70.
My point is why they have given more preference for women and children. After all, they are also individual level only. So nation is the first thing that we have to give top priority. Only then comes other things, you know. But anyway, that is for discussion and debate that we can deliberate.
Yes, in sedition, they have removed the section sedition.
I know.
They have changed it. But still that offence exists against the state.
That is there. But then they have not given state and all. They have. If you see the sections, the organization of the sections, you see women body first, women, and then these are given top priority. Earlier, we used to see that 124 and all, they were given earlier, you know. The initial sections only covered the state. Later on, your marriage and all, I mean, they are given last, 498, like that they have given offences relating to marriage and all are given at the last. So why they have given? Because individual offences against individual will be the last ones to come. When the nation is safeguarded, when the nation is protected, the members in the state automatically will also get the protection. That was the concept when IPC was enacted, but then I don't know what is the priority.
Acts are there, ma'am. Unlawful act.
I know unlawful Mokaka and all, they are there. They are there, and
so
they.
already special acts are available to deal such offences. So here IPC mainly to maintain law and order in the society, and maximum crime is taking place against women and children only. So they give more importance to the.
And this community servicing also, and for electronic things, because they.
That's the one way good, ma'am. It's like reforming the committed offense.
And gender neutrality also, I don't know, because more men folk also these days are becoming, vulnerable to male, female.
Also very important thing, ma'am. Gender neutrality. Earlier, particularly rape and all, they used to mention only man and male person.
I know.
Now it is a gender neutrality, means even the woman can also commit an offense against the man.
No, when women commit offense also, they should also be treated as an offenders, and they should be accordingly punished.
Everywhere that equality is there. So
I know.
in the crime also, they wanted to send a message that equally responsible like that.
Organized crimes are also given, and chain snatching we used to have lot of SOPs developed and all, but we don't find nomenclature, snatching, chain snatching, mobiles.
Even present existing IPC, we used to register under robbery actually.
Robbery, yes.
The modus operandi is entirely different. It's not a robbery actually.
So though there are mobile properties involved in both the cases, but then there is a little, difference in that,
Yes.
So that's the reason why they have included snatching also as a separate heading.
Yes, earlier some state also, some states they have given a amendment. They brought an amendment specifying the chain snatching, but IPC it was not there. So
I know.
They have brought.
That's also good. I mean,
IPC प्री-इंडिपेंडेंट एरा में इनेक्ट हुई थी, तो उनको जो अपना स्टेटस था उसको आगे रखते हुए उन्होंने सेडिशन वगैरह को बड़ा इम्पोर्टेंस दिया था. अभी चेंज हो गया सिनेरियो, अब क्राइम का पैटर्न भी चेंज हो गया. आज सेडिशन
और मोर टेक्नोलॉजी ड्रिवन क्राइम्स तो ज़्यादा हो रहा है ना, इलेक्ट्रॉनिक वो कंप्यूटर असिस्टेड, कंप्यूटर मीडिएटेड जो क्राइम्स हो रहा है उसका भी. So they have given a broader this thing wherever crimes are committed, and by using this medium of computer and all electronic gadgets, तो उसका भी थोड़ा emphasis is given more on that. And one more thing, as I know, sedition and all, as you rightly said, I mean, and if you see the priority order of giving the number sections, so these are taking little last priority. That was my concern. So first priority was given to these things, and then gradually if you see body of the woman, bodily offense, then later on, I mean, like that it is easy. Now for us also, older acts, any act for that matter, so we used to have section 2 specifically for definitions. So it will become easy for us, instead of remembering the separate section from 6 to 52, it would have been little difficult for us, specifically remember. Now that we are familiar with IPC for so many years, maybe some sections they are still fresh in our mind. But then it's good, one section, common section, section 2, and then subclasses if you give, that becomes very systematic and easy to remember also. That is also one good welcome sign that is given on that. And drastic reduction, those which are redundant, which are no more now considered as crimes, offences and all, they were removed completely, like 377 and all, so there was no point. So they have removed that 370, unnatural offence kind of thing also they try to remove from the act. So these are some of the acts, and for today only we will restrict ourselves to IPC and CRPC and all. Maybe tomorrow and day after we will discuss that. And switching back to MLC sections, so simultaneously these two things I want to cover. IPC anyway is over. Now we will also try to cover some of the MLC things also. Now what do you understand? I would like to ask some topics or some definitions. I would like to know whether you are aware of those definitions or not. I would like to know. Now, for example, we say when we talk of death, there are three aspects I told you with regard to the death. One is cause of death, mode of death, and the third one being the, what is the third one?
Time since death.
These are called, when you talk of death, these are very important. Now, what are the three modes of death? Can anybody tell me? When we talk of mode of death, there are three modes of death. What are they? What are the three vital tripods of the life? What are three important tripods of life? What are the three vital organs? Nervous system, nervous system, circulatory system, respiratory. These are the three vital systems, है ना? नर्वस तो एक है, सर्कुलेटरी ब्लड का एक है, रेस्पिरेटरी, है ना? ये तीन हमारा ट्राइपॉड बोलते हैं, लाइफ ट्राइपॉड बोलते हैं इसको, है ना? So these are important. If these are missing, if there is a cessation, if there is a stoppage of this function of these three important systems in the body, then you can say that the person is dead, isn't it? When can you say the person is dead? When the vital system, vital organs stop functioning. There is a stoppage of the functioning of these vital organs. What are the three vital systems? Nervous, circulatory, respiratory. Isn't it? You got that? Is that clear?
Yes.
Yes, ma'am.
Now, there are only three, we know them colloquially as nervous, circulatory, but then there is also technical terms. Because now that you are participating in the All India competition, so you are expected to know certain technical terms. Now, there are three technical terms. When we talk of mode of death, you need to remember three important technical terms. One is coma, other one is syncope, the third one is asphyxia. What are the three modes? Coma. Coma, when we talk of nervous system, we said, one important thing. So anything which is related to nervous thing, if that gets deteriorated, we call such a situation as coma. So coma means death involving vital center of the brain system. So brain is the main thing for all nervous system. Brain is the, it is like a, what you call, a very important vital center point, isn't it? Now when brain is dead, center point, isn't when there is a death of brain, then you call such a mode of death as coma. He has gone to coma, he went into coma, bolte na abhi. That is called the dysfunction or the death of vital center of brain is called coma. And syncope means stoppage of heart. Death due to stoppage of heart is called syncope. How will you pronounce it? S-Y-N-C-O-P-E. Syncope. S-Y-N-C-O-P-E. That is called the stoppage of the heart. So that is circulatory system, isn't it? Circulatory system. So circulatory system stoppage is called technically as syncope, whereas nervous system death is called coma, and the third one, when you talk of respiratory system, lungs and others, respiratory system ka matlab lung and others, then it is called asphyxia. Asphyxia, absence of oxygen, insufficient supply of oxygen, that is called asphyxia. इसका spelling क्या है? A-S-P-H-Y-X-I-A, asphyxia. A-S-P-H-Y-X-I-A, asphyxia. So what are the three modes? One is coma, second one is, what is the second one?
Syncope.
Second is syncope, third one is what?
Asphyxia.
Asphyxia. Asphyxia, all of us are familiar. You are hanging, isn't it? Smothering, strangulation. Recently we have been hearing the COE case. What is the COE case? That may come in the medical legal oral test also. You should keep monitoring that case, COE case. What was the COE case which happened in Bangalore and spread to Goa? What was that? Are you keeping track of that case or not?
Smothering.
She killed her own son, isn't it? There was a dispute between wife and husband, applied for a divorce, got in the process of getting a degree for divorce, and it came to the maintenance, the custody of the child, and then the husband was asking for the visiting rights of the son, and they have granted him over phone. You can talk to your son over phone. Then he has gone a step ahead, and then he requested the court to grant him to go for video call, because video you can see the person. Now when video call is also granted, then he has again gone a step ahead, and then please arrange some physical meeting of the son, so that the emotional bondage and all will be developed only when I meet him in person. That's what is the request which has been put forth by the husband. Now court also positively reacted towards that. They granted him the physical meeting, and this lady, being a very intelligent lady and top education में इतना पूरा degrees पढ़ा है, foreign countries में बहुत पढ़ के आया, then she started her own firm. She is an expert in artificial intelligence and all. I mean, with all these good things, in spite of all these things, she also is very possessive in certain things, very rigid about certain things and all. So she never wanted to give the right, though the court has given the permission for the husband to meet the son in person, but she was too possessive about the boy, and then by any means she wanted to retain the boy. The custody of the boy she was very much interested in. But then at the same time, when a court order is there permitting the husband to meet the son in person, she cannot disobey the order of the court. That amounts contempt of court, isn't it? So for that reason she was not able to come out with any plan. Ultimately this is what she did, and then she just thinking that particular Sunday is the visiting right day, so she gave messages to him saying that on a particular day, Sunday, you please come, and this is the place where I'll make my son available, you can meet him this and that. She gave messages, and based on the messages this man drops at the place, flying all the way from Jakarta, only to find that these two people are not there at all. So the previous plan was that she moved with her son to Goa and booked some hotel over there, and then it was a stay for another 4-5 years, and then suddenly she changed her concept, and the very day when she checked in, she has killed the boy. And then initially she wanted to plan everything so perfectly that she doesn't want her son to undergo any kind of a pain during death. So to avoid that, to ensure that, what she did, she purchased cough syrup, a small bottle and a bigger bottle also. For public she has shown only the small bottle, because everybody may suspect, for a small boy of 4 years age, why are you buying that much cough syrup? So cough syrup, how much drowsiness it creates. So she ensured that he consumed, engulfed all that cough syrup, and then ensured that he is almost into a kind of sleeping thing, and into sleep. Then she tried to smother, try to strangulate him, and ultimately you could see all signs of asphyxia now. So you should also monitor, if such a case is given to you, you should completely watch that case. It is so viral in YouTube and all. I wish everybody to see that and then try to understand. That may come in medical legal also, we do not know. So that is one thing. So what are the three modes of death? One is coma, the other one is syncope, the third one is asphyxia. Asphyxia, we talk about which system? Respiratory system. First one, coma, is relating to the nervous system. And syncope is little new to us. Otherwise coma and asphyxia we know. Only syncope is little new to us, so we should remember that word. SYNCOPE, syncope is the word. which is used when there is a failure in respiratory system, when there is a failure in circulatory system, or the heartbeat, if it stops, it is called syncope. Stoppage of heartbeat is called syncope. So I hope now you understood what are the three modes of death. Now coming to the skin changes, especially in suppose there is a phosphorus poisoning that you are suspecting. Now as I told you, there will be some change in the PM stain. Now similarly, for if somebody is poisoned with phosphorus and all, you see that the skin becoming a little yellowish in color. It becomes yellowish in color in case of in case of poison with the phosphorus. This is what you need to observe. And one more thing is, you must have heard about adipose hair, then putrefaction or mummification. So what is the difference? When do you call that adipose hair has been set in? What is the medical legal significance of that particular process, adipose hair? Did you ever heard about the word adipose hair? ADIPOCERE. Are you aware?
Yes.
Now, what is that? What happens there?
फैटी एसिड में कन्वर्ट हो जाता है.
हाँ. So adipo means fat. Adipo means fat. Sera means wax. So the fat is becoming like a wax. What is the when under what circumstances and under what conditions this particular process will happen? Adipose hair.
Not fully clear.
No, this is not in every death this will happen. This condition of forming adipose hair will be prevalent only in certain conditions. What are the conditions you have to remember? Now, if it is a humid condition, lot of humidity is there, but still it is warm also. In such conditions, where anaerobic, that means where there is no aeration proper and all. So, if the bodies are buried in such graves, damp graves, that means there is still lot of moisture is there and all. So, these conditions are very favorable for adipose hair formation. So, what are the conditions? What are the conditions? It should be warm, but it should also have humid. It is warm. Warm and humid. Warm and humid, and there should not be enough air. That condition is called anaerobic. What is that condition? Anaerobic. Aerobic means aerobic means oxygen is there. Anaerobic means oxygen is not sufficient.
Oxygen is not
there. So anaerobic plus warm plus humid is equal to adipose hair. Warm plus humid plus anaerobic is equal to the adipose hair. Adipose hair. So what is the MLA? What is the significance? Because as you rightly said, the body fat, because we have proteins inside the body, we have fats, isn't it? We have lot of things, we have muscle, we have lot of things inside the body. Now, the body fats in this particular warm and humid conditions, they will be converted into fatty acids. They look like wax. Fatty acids are, in appearance, they look like wax material. So you see that the entire body features are preserved. See, once it becomes, the fats become fatty acids, it will be, the entire features, you can identify the person by facial features and all, because they are retained. The facial features and all are well preserved, isn't it? So when they are preserved, then whenever there is a death, if somebody is found missing, and the same missing person has now become, the body has become an adipose hair, now it is easy for you to establish. And then say the identity, after establishing the identity, the person whom you thought is found missing is none other than the person who has become now, whose body has now become adipose hair. That means you are able to identify the body, isn't it? So that is one very important medical legal aspect that is associated with adipose hair. So if you want to write a formula, then what is the formula? Formula is that warm plus humid plus anaerobic plus features well preserved is equal to your adipocere. So that is how for small little things you have to make a formula so that it becomes easy for you to remember. Then, so even bodies which are immersed in water or muddy, where a lot of mud is accumulated and all, so such conditions also, because dampness promotes the adipocere formation. So like that, mummification is something opposite to adipocere. So if you have to remember adipocere and mummified mummification, they are opposite to one another. That means what? Whatever conditions that favor adipocere will not favor definitely mummification. So mummification, what is required? Drying, complete drying of the musculature inside and all. You will see only a thin plastic kind of a thing covering the bones and all bones and all you will see inside and all. It is it is also a kind of a preservation. Now, so what are the conditions do you think where there is no water at all, isn't it? So water is not there, heat, enormous heat is there, air is getting heated up. So such places, dry places, hot environment, these conditions promote the formation of mummification. So unlike adipocere where you see moisture has to be there, humidity is to be there, the air should not be there. But here lot of air should be there, it should be dry, it should be sandy, almost desert kind of a environment should be there. So desert kind of a atmosphere or environment promotes mummification, whereas the other opposite thing that is the humid condition and anaerobic conditions promote adipocere formation. So the formula if you want to derive for mummification is a dry plus desiccated plus hot and air. The other one adipocere is without air, isn't it? This is with air. And then desert. Desert is the atmosphere. Desert atmosphere will promote the mummification. That is what you have to remember. And the body here becomes thin. It doesn't become, like in fatty acid conversion, you see the wax formation. You don't find any wax formation here. But body will be dried up completely because the body water will get evaporated because it's a dry atmosphere, desert atmosphere. You see whatever water content that is there inside the body, it gets evaporated and the body becomes shrunken almost. It becomes like a leathery it becomes. And then the body also becomes quite thin and all. But it also, when will it happen? Any burial grounds which is with a shallow graves and all, so in such cases you find this type of mummified bodies. Now the time period that we can think of is ranging from 3 months to 1 year. But depending upon the conditions, there is such a variation. So mummification may get completed within 3 months, or it may prolong up to 1 year. So these are two things, adipocere and then the mummification are two very important aspects that you may have to remember. And one more thing which is important from medical legal point of view is the euthanasia. Euthanasia, concept of euthanasia. What do you understand by euthanasia? Malum nahi. Euthanasia is mercy killing. Mercy killing. Suppose a person is almost has become now like Nirbhaya. Nirbhaya case we are all familiar, Delhi में हुआ ना, उसमें गैंगरेप हुआ बच्ची के साथ और ये बच्ची ऐसा हालत बना दिया इनके प्राइवेट पार्ट में ऐसा रॉड्स घुसा दिया ऐसा पूरा करके, then she has become almost bedridden for so many days and she is not able to discharge her day-to-day work and she has restricted herself only to a bed and all. It has happened in Shanbag case also, a nurse case who has been Shanbag case. Euthanasia बोले तो शानबाग का केस याद आना तुरंत, है ना? शानबाग केस में भी वही हुआ ना, वो औरत के साथ नर्स था, वो उनके साथ भी बहुत गैंग रेप बलात्कार हुआ था, याद आया? तो उसी के साथ
उसका वायर से उसको थोड़ा गला दबा दिया।
वो भी दबा दिया। वो पहला वो गैंग रेप हुआ था उसका, तो वो भी उसका भी डेथ ऐसा ही कर दिया, उन्होंने डेथ भी नहीं हुआ, बहुत साल इन्होंने वही बेड के ऊपर ही वैसा ही वेजिटेबल जैसा बना दिया। तो उसी से हमको ये एक्ट में भी वो सेक्सुअल अफेंसेस एक्ट में भी थोड़ा 2013 में हुआ ना अमेंडमेंट का। So with all that it has come. The Shanbag case is very important when you talk of euthanasia. So euthanasia is nothing but mercy killing. Mercy killing. Mercy killing means the patient will make an application. See, there is no purpose in my life because I am not able to do any work and I am only restricted to bed. I have become dependent on somebody. It will be very difficult for me to prolong life further. So there will be a petition from the side of the patient. That is almost terminal stage of illness if somebody is there and somebody is willing to die. So the doctors have come up with this concept of mercy killing, otherwise called as euthanasia. EUTHANASIA, euthanasia. Euthanasia means mercy killing, MERCY, mercy killing. किलिंग दया से किलिंग करना, इनके ऊपर तरस खा के डेथ ग्रांट करना। समझ में आ रहा?
yes.
किसी का लाइफ लेने का हमको हक नहीं है ना, मगर ये मर्सी किलिंग में क्या होता, ऑन द रिक्वेस्ट ऑफ द पेशेंट, बिकॉज शी डजंट वांट टू प्रोलॉन्ग हर लाइफ बिकॉज ऑफ हर कंटिन्यूअस लास्ट स्टेज ailment, she or he doesn't want to live further. So they make a special request to the management, hospital management, that I no more want to live. So please grant me death. So there are 2-3 types in that, passive euthanasia, active euthanasia. Like that there are, terms. Active euthanasia is, killing the person by giving a very strong drug and all. So that is instantaneous death. Passive means, it is a little painless kind of euthanasia. But in India, we have not given any legal sanctity. It's not granted. In India, we don't believe in euthanasia and all. So we only believe in preserving lives. We don't kill people, either in the name of euthanasia or otherwise also. India, this is the one. So euthanasia, you have to remember this. Then you should also differentiate when we talk of death, because death is there in the syllabus. Examination of dead bodies, death and all, injuries and all, it is all there. So we thought we will spend some time today on these different concepts of death and all. Now we know that there are 2 types of death. One is somatic death, the other one is molecular death. Now why are these 2 aspects important? समझ में आ रहा?
सोमेटिक डेथ मतलब मोलेकुलर डेथ 2-3 आवर्स तक बाद में भी लाइफ रहती है, सेल्स में पूरी तरह से डेथ नहीं होती।
हाँ, वही सेल्स में पूरा डेथ होना मॉलिक्यूलर डेथ बोलते हैं। Now why should we be very particular about this? So we know that organ donation का एक नया कानून भी है ना हमारे पास, जो भी when they leave a thing before death, if they give voluntary that after my death my organs I am going to donate and all. So if somebody who needs that particular organ, if this man is willing to donate, उनके काम में आता ना, like cornea transplant and all, these things are there, So this will be very important when you talk of transplantation. So the somatic death and then the molecular death are very, very important, because now you have to know which organ will die first, which organ will die later, and accordingly those organs have to be removed from the body of the deceased, isn't it? Otherwise, after a lapse of so many hours, if you try to remove the organ and if you also try to transplant, it doesn't work. It doesn't work, because by the time you have removed that organ, it is already dead, it has become useless. Then what is the point of donating such an organ, isn't it? So when you talk of transplantation of the organs, human organs and tissue, there is an act called Transplantation of Human Organs and Tissues Act 1994. So under this, if some donor is interested in donating his organs after his death, then it is permitted. it is permitted. So accordingly he will leave his consent form before his death, and then that can be the relatives of that deceased can show this consent form to the doctor concerned. So within that time frame he is going to remove that particular organ, and then it is going to be harvested. Then it will be given to the recipient, whosoever is in need of that organ, that can be given to that recipient. That is the concept. Now for that you need to understand when a particular organ is going to completely die, that means when it is going to become completely defunct. That means what is the time where it cannot be used for transplantation anymore. So that time period is very, very vital, and we need to understand about that. So when we talk of this, the death of organs in that order, brain is the first one, because it is the entire communication thing is resided in the brain. If that is dead, almost every organ is dead. Organ which is going to die within 5 minutes is brain. Brain is the first one to die. Then followed by peripheral nerves, and then liver it takes 15 minutes, and for kidney it takes 45 minutes, for heart it takes 1 hour, and for cornea. That is the reason most of the cornea transplantations are very, very successful, because the time period you see 6 hours. When a person dies, even up to 6 hours also, if you collect the cornea, you can still go for transplantation of cornea. So you have to understand these things. So for brain it is the only 5 minutes, and for peripheral nerves and liver it is 15 minutes, kidney it is going to be 45, heart you see 1 hour, and cornea it is still 6 hours. And then skin transplant if you want to do, 24 hours is given. And like that bones, if you want to bone transplant, किसी को भी leukemia हो गया, leukemia का मतलब वो बोन मैरो का वो हो गया, कैंसर हो गया, तो उसमें बोन ट्रांसप्लांटेशन करना है, तो 48 आवर्स के अंदर डेथ होने के बाद 48 आवर्स तक ये बोन को रिमूव कर सकते, उसको ट्रांसप्लांटेशन के लिए काम आएगा. वैसा ही ब्लड वेसल्स है, इसका 72 आवर्स रहता. So these are the things which you need to understand. Now this become very important when you talk of transplantation under the Act, Transplantation of Human Organs and Tissues Act 1994. Now there is in between a term called supravital reaction. What do you understand by this supravital reaction? This is simply that the biological properties of the component parts may still be demonstrable. For example, some facial muscles are there. Even if the other systems like your heart, respiratory system, and then the brain, even if they are not functioning, some of the muscles still they do function. For example, in a dead body, if you try to give some injection kind of a thing near the muscle, facial muscle, you will see some reaction. As if somebody is alive, you see that reaction. So that means what? There is a supravital reaction. So these are very important. Now during supravital period, the organ and tissue can be harvested for transplantation. So this is very, very important. Supravital period is the vital period. It is the ideal period where you can remove the organs, and then these organs will become fit for the transplantation. Isn't it? Now you have to understand this. And molecular death, it will occur not all of a sudden. It is a very gradual phenomena, and then it occurs piecemeal. That means piece by piece, part by part it occurs. So that is the reason why we call death not as an event. Death is a process, because it is a continuous process. Death is a process, not an event. This is the thing you have to remember. Now, suppose the organs are harvested after molecular death, it is of limited or less value. So, if at all the organ has to be removed, and if at all your aim is to give it for donation, then it should be within that time frame. Before the molecular death happens, these organs need to be removed and they need to be donated. That's what you have to understand. Now, there is one more concept which is associated with death called suspended animation. What is that? Suspended animation. What do you understand by that? Any idea?
इलेक्ट्रोक्यूशन में ये सस्पेंडेड एनिमेशन
क्या होता है
वो पूरा क्लियर नहीं है, लेकिन ये दो में।
हाँ, तो इसका मतलब क्या है, वाइटल फंक्शंस हमारा रहता ना, तीन बोले ना हम वाइटल फंक्शंस, वो नर्वस का एक होता है, रेस्पिरेटरी का एक होता है, और तीसरा क्या है, हार्ट का एक होता है, इजंट इट? सर्कुलेटरी, रेस्पिरेटरी, नर्वस, ये तीनों है ना हमारा। अब ऐसा केसेस में थोड़ा हमको पल्स नहीं मिलता, कभी कभी इतना लो होता, पल्स नहीं मिलेगा आपको, कुछ भी साइंस ऐसा नहीं मिलेगा, हम समझेंगे आदमी तो डेड हो गया, ऐसा समझेंगे, मगर इसमें फिर भी ये वाइटल ऑर्गन्स का वो काम जो है वो मिनिमम से मिनिमम रहता, इसीलिए हमको ईसीजी फ्लैट रहेगा, हम समझेंगे आदमी तो मर गया बोल के, और ये सब ऐसा फंक्शंस लो रहेगा। ये जो सेल्स में ऑक्सीजन डिजॉल्व जो रहता है ना, वो काफी है आदमी जिंदा होने के लिए, उतना ही रहेगा, इसीलिए आपका ईसीजी भी पॉजिटिव नहीं निकलेगा और कोई भी वाइटल ऐसा नहीं निकलेगा आपको। इसीलिए डेथ कंफर्म करने के लिए ये रिवर्सिबल होता, नहीं रिवर्सिबल हो रहा, इरिवर्सिबल हो रहा, वो देखना है। वाइटल कुछ दिए तो रिवाइव हो गए तो इट इज रिवर्सिबल बोलते, सो इरिवर्सिबल माने डेथ, कंप्लीट डेथ। तो सस्पेंडेड एनिमेशन ऐसा होता है, उसमें ये पूरा मिनिमम रहता, मेटाबॉलिक रेट जो होता है रिड्यूस टू मिनिमम, एंड यू कैनॉट डिटेक्ट विथ एनी मशीन, है ना। ईसीजी मशीन से देखे तो भी फ्लैट ही रहेगा, मगर आदमी तो जिंदा रहेगा, क्यों बोले तो इनका वाइटल फंक्शन जो होता है जो मिनिमम लेवल में होता है, इसीलिए वो कॉन्सेप्ट को सस्पेंडेड एनिमेशन, सस्पेंडेड एनिमेशन इज रिवर्सिबल, वेर एज डेथ इज इरिवर्सिबल, रिवर्स नहीं होता डेथ में। ये सस्पेंडेड एनिमेशन में कुछ ऐसा दिए तो, थोड़ा ऑक्सीजन वगैरह दिए तो उनको रिवाइव होता। ये डेथ में अगर वेंटिलेटर में रखे तो खाली मैकेनिकल का मूवमेंट का लंग का होता, मगर द मोमेंट यू रिमूव द वेंटिलेटर इट विल बी अगेन डेड, सो दे रिवर्सल नहीं होता, इरिवर्सिबल होता डेथ। ये सस्पेंडेड एनिमेशन जो होता है वो रिवर्सिबल होता है, इतना तो याद रखना। सस्पेंडेड एनिमेशन and then this transplantation, then death of organs, and what is supravital, supravital reaction क्यों बोला है, important बोल के बोला है हम, what is the significance of supravital in transplantation?
तो सुप्रावाइटल पीरियड के अंदर,
हाँ, पीरियड के अंदर अंदर हम ऑर्गन्स को निकालना है ना, हाँ निकालना है। और सबसे कौन सा, किसका कौन सा ऑर्गन का शॉर्ट लाइफ है?
ब्रेन।
हाँ, 5 मिनट शॉर्टेस्ट जो होता है ब्रेन, लॉन्गेस्ट जो होता है किसका होता है? ब्लड वेसल्स का,
ब्लड वेसल 72 आवर्स।
हाँ 72 आवर्स। बीच में बोन का भी काफी है 48 आवर्स तक। तो कार्निया का सक्सेसफुल क्यों होता है ट्रांसप्लांटेशन? कार्निया, हाँ कार्निया मतलब किधर होता है कार्निया? आई में होता है, तो उसका तो 6 आवर्स है, इसीलिए वो ट्रांसप्लांट करने का जो वेरी इंपॉर्टेंट बनता है उसका, है ना। तो किडनी का भी, ये बाकी ऑर्गन्स का, किडनी, लिवर तो लिवर भी छोटा है, वो 15 मिनट्स का ही है खाली, किडनी का भी ज़्यादा है, 45 मिनट्स तक है। उस सुप्रावाइटल रिएक्शन के बारे में भी हम समझना है थोड़ा, और एडिपोसिल के बारे में भी बोला है। देन व्हाट इज द अदर इम्पॉर्टेंट थिंग, देन कोमा भी हो गया, इसका भी हो गया, देन मॉलिक्यूलर भी हो गया। हाँ, आप सही सही बताया, ड्राउनिंग में और इलेक्ट्यूशन में बोले ना। एंड नॉट ओनली दैट, सम योगा वो करते ना, जो सन्यासी तपस्या वगैरह करते, वो भी प्रैक्टिस करते योगा में, वो भी है। योगा इज ऑल्सो अनदर एक्सेप्शन, ड्राउनिंग, electrocution, and then this yoga also you will see that, हाँ प्रैक्टिस योगा, उसमें तो ये सस्पेंडेड एनिमेशन बनता है ना। देन व्हाट एल्स, आई थिंक आज के लिए थोड़ा काफ़ी है, वी हैव डिस्कस्ड मेनी एस्पेक्ट्स। टुमारो विल ट्राई टू सी दैट एविडेंस एक्ट नया क्या है, ओल्ड वर्जन क्या है, एंड इसके अलावा वी आल्सो ट्राई टू सी सम फिंगरप्रिंट्स वाला, और नहीं तो कुछ और टूल मार्क्स के बारे में, नहीं तो फायर आर्म्स के बारे में, वैसा तो अलग आप ही बताओ ना कौन सा सब्जेक्ट होना चाहिए, उसी के हिसाब से जाएंगे ना हम भी। इंस्टेड ऑफ माई ओन चॉइस यू कैन टेल योर चॉइस कल के लिए।
टूल मार्क्स ठीक है मैम।
हाँ बोलिए बोलिए।
सर क्या बोल रहे हैं?
टूल मार्क्स पे ठीक है, कल करेंगे।
यस मैडम,
टूल मार्क्स तो वेरी शॉर्ट है ना, इसमें इतना बड़ा नहीं है। बर्गलरीज एंड टूल मार्क्स दिया ऐसा ही दिया है उसमें।
मैडम फायर आर्म्स का ले सकते हैं?
हाँ फायर आर्म्स का भी ले सकते, फायर आर्म्स का ले सकते। कौन सा है, कौन सा रिकोशेट शॉट, टैंडम बुलेट क्या होता है, वो सब आई थिंक वी कैन कवर दैट, फायर आर्म्स एंड आर्सन। एंड इसमें थोड़ा मेडिको लीगल और भी इंजरीज के बारे में वगैरह वो भी थोड़ा देख लेंगे, है ना।
जी मैडम।
हाँ क्या है,
दोनों में एक टॉपिक पे कर सकते हैं।
अब वही टाइम के हिसाब से ना, टाइम ज़्यादा है तो अभी बिकॉज मोर डिस्कशन विल कंज्यूम मोर सब्जेक्ट, ऐसा देखेंगे, देख के फिर जितना कवर कर सके उतना करेंगे, है ना। राइट, so we'll end the meeting now. Are you feeling that there is some useful things happening this one and a half hour?
Yeah, definitely ma'am, very useful.
Yes.
तो जिसका हम डिस्कशन कर रहे हैं उसका पूरा आपको पेन ड्राइव में पूरा मटेरियल सॉफ्ट कॉपी मिलेगा, कोई चिंता करने का बात नहीं उसमें। So we are putting all our efforts to give you the maximum, the maximum content. And then not only just mere giving, we'll also make you understand things, assimilate things and reproduce the same in the exam, so that at least this time you should be firm in getting at least 1 or 2 medals. That is our aim, है ना। Right. Thank you. But कोई आके लेके नहीं गए ना, आके गए अभी कोई आदमी नहीं है ना, वो बुक्स वैसा ही पड़ा है घर पे।
आएगा मैम, वो ड्यूटी स्टाफ है, थोड़ा एडजस्ट करके आएगा, इसलिए मैं घर का ही बोला, वो उतना टाइम में पॉसिबल नहीं था, वो ले लेगा आज आके।
हाँ घर में अब कल के लिए तो अब तक तो even if I am not there, my husband is there. I have told him already to hand over the books. Even if I am not there, somebody can come to my residence, collect them and then go. That can also happen.
आएगा, वो आ जाएगा, मैं बात।
हाँ, so practical तो ऐसा ही ऑनलाइन पे तो नहीं हो जाएगा, वो practical will become only when you come physically there. And one more thing I just wanted before we wind up, the working lunch के लिए what is the amount that is allocated for you, how much can you afford, so that accordingly we